Hey everybody, this one is called Privileges Equals Slavery, and it's more true than you know. First of all, I'm not a liar. Well, I meant a lawyer. Well, no, actually I meant a liar. All lawyers are liars, right? You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything, and I'm open to any ideas. There's 4 types of people you will meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how on earth can they know when or if their rights and freedoms are being infringed? Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the pigs. All tyranny needs to gain a foothold is for people of good conscience to remain silent. This is a Supreme Court case, Carlisle versus United States. 1873, the rights of sovereignty extend to all persons and things not privileged. Okay, that's the operative word, not privileged. And so when you partake of privileges, you convert yourself into a slave. They extend to all strangers resident therein. Okay, well, look in the Bible as to what a stranger is. Not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they're within his territory and owe a temporary allegiance in return for that protection. So, again, these are all words that are found in the Bible, actually. Read what a stranger is in the Bible in the Old Testament. But when you partake of privileges, then you lose your sovereignty. And that's why they have to give out all those freebies to those so-called illegal aliens, because they need to get them in a contract. It's all about slavery. It's always all about slavery. Why do you think that the communists want to give away all the freebies to the so-called illegal aliens? Property is subject, and subject is property. The Congress shall have power to dispose of and make all needful rules and regulations respecting the other property belonging to the United States. Regulations apply to property. This is the Canadian Ownership and Determination Act. Section 2, in this act, own means subject to the regulations. Again, if you are subject to the regulations, you are property. You are owned. A property is subject, and a subject is property. And this is a summary. You know, I can't tell you. And people on my group, sometimes they're so dense. You know, this is a summary of about 2 pages that are found in that case, Penhall versus Doan's Administrator. Okay, it's a summary of what it says. People send me emails, I can't find that. Well, I'm not surprised. You won't be able to find it. You won't be able to find it because it's not there. It's a summary of about 2 or 3 pages of what the court is saying. I should say, yeah, a summary of 2 or 3 pages. So you won't find it, so don't send me an email saying, I can't find it, because it's not there. You have to have a little bit of gray matter and read the case, and you'll find it. It'll be a summary of what 2 or 3 pages say. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Jurisdiction equals contract. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so that you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. This is the front page of my channel. The arrow is pointing at the bell. The subscribe button's already clicked, otherwise it'd be red. And the bell hasn't been clicked because it doesn't look like it's vibrating. A subject equals contract. All subjects over which the sovereign power of the state extend are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may also be pronounced as self-evident. It's obvious. The sovereignty of the state extends to everything which exists by its authority or its permission. Martial law extends to property and to persons, whether they're subjects of the enemy or aliens to that government. That's Libra Code, Article 7. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those which the law, in its humanity, affords him. He is, for the time being, a slave of the state. A subject is a slave. If a man be found stealing any of his brethren of the children of Israel, maketh merchandise of him, or selleth him, then that thief shall die. Thou shalt put evil away from among you. Woe to her that is filthy and polluted, to the oppressing city. Okay, this is talking about, cities. She obeyed not the voice, she received not the correction, she trusted not in the Lord, she drew not near to her God. Her princes within her are roaring lions, her judges are evening wolves, they gnaw not the bones till the morrow. Her prophets are light and treacherous persons, her priests have polluted the sanctuary, they have done violence to the law. And that's Zephaniah 3, 1 through 4. There's a lot of cities around here that fall into that category. A U.S. citizen does not mean a privilege. The privilege is a contract. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. Government employee equals privilege. The term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. So, government employee is the privilege. Just because you're a U.S. citizen does not mean that there's a privilege, but the government employee is the privilege. This is the Certificate of Title Act, Transportation Code 501.004, applicability. This chapter applies to a motor vehicle owned by the state or a political subdivision of the state. So again, if you put the state's registration on your vehicle, you can't get the registration without having the certificate of title, getting that certificate of title, okay? And so the certificate of title is the privilege. I should say the registration is the privilege. The government employee is the privilege. If you have state plates on your vehicle, then you are participating in a privilege. This is the Federal Tax Lien Act of 1966. Public Law 89-719 at 80 Stat 1130 and 1131. In the definitions section, security interest. These are all commercial terms that are found in the Uniform Commercial Code. The term security interest means any interest in property acquired by contract for the purpose of securing payment or performance of an obligation or indemnifying against loss or liability. A security interest exists at any time. A motor vehicle. The term motor vehicle means a self-propelled vehicle that is registered for highway use under the laws of any state or foreign country. Okay, there you go. Okay, that's under the Federal Tax Lien Act. If it's registered, then it's a motor vehicle and you're liable to everything. Okay? Contact information. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group at Facebook called Sovereignty International is being deleted. You know, it's been months since I've been there. I have no interest in going there. Facebook is a has-been. It's going to be the next MySpace. And good riddance. My Yahoo private group is called Administrating-Your-Public-Servants. My Google private group is called Administrating-Your-Public-Servants. Follow me on Twitter at EngineerWin. Follow me on Steemit at Sovereignty International. And I have a BitChute profile, although I don't have that many videos up there because BitChute doesn't allow me to upload anything over 500 megabytes. And a lot of my videos are well over 500 megabytes. And I've got a Patreon profile, and I want to say thank you for all of my Patreons. And I'm trying to upload and give you guys all of the first in line for everything. I appreciate all you're doing for helping me stay afloat here, because if it wasn't for my Patreons and my subscribers to my website, you know, it'd be pretty tough, let me tell you, because I've been out of work for 7 years. So this is, you know, and YouTube is demonetizing everything they can get their hands on, and because of all of their censorship. Don't get me going. You're going to get me going here. So anyways, subject matter jurisdiction. An officer who acts in violation of the Constitution ceases to represent the government. Subject matter jurisdiction. A government employee is a privilege. The statute creates a rebuttable presumption of residency for anyone who meets the following criteria. However, no such person shall be considered a resident for purposes of this chapter unless such person is either a citizen, a United States citizen, or alien with legal authorization from the U.S. Immigration and Naturalization Service. And that's a letter from Jennifer Ammons, General Counsel, Georgia Department of Driver Services, dated 5 December 2012. Rebuttable presumption, okay? So everything's under presumption, and that's a Uniform Commercial Code stuff. Again, and this is privileges are slavery. The rights of sovereignty extend to all persons and things not privileged. If you have a privilege, you're not sovereign, okay? You have to walk away from those privileges. That means government employees, that means vehicle registration, that means anything associated with that. Now, with people that are on Social Security, worked all their lives, and now that's all they can live on, you know, I understand your situation. And the way the courts look at it is each case is a separate issue. It's all about contracts. So, and it's all about evidence that you give against yourself. And if you don't give the evidence, then they have no evidence. It's all about evidence. So don't give the evidence against yourself. Do not give them social security numbers, dates of birth. They'll never find it out then, and it won't become an issue. If the court determines at any time it lacks subject matter jurisdiction, the court must dismiss the action, okay? So that's how you do it, okay? Is you show that they've denied you due process. When they deny due process, they lose subject matter jurisdiction. An employee of the United States is not qualified to serve as a member of a grand jury in any district. Okay, and that's United States versus Griffith, U.S. Court of Appeals in the District of Columbia. So Social Security, again, is a privilege. Okay, an employee of the United States has a Social Security number by definition. A bill of indictment. Okay, there's another denial of due process. Is a fake bill of indictment. A bill of indictment has to say it's a true bill. It's called a bill of indictment. If it doesn't say it's a true bill, then it's not a bill of indictment. And it must be signed by the county attorney, and it must be signed by a grand jury foreman. Now, you pretty well got to take their word that that is all valid, but the purpose of the county attorney signing it is to verify that it was properly done. That county attorney is accepting responsibility for it. And so, if that county attorney has a stamp on there for a signature, then that's a problem. And I've seen indictments that did, but they didn't. They also didn't say true bill, and that's another problem. Okay, so again, it's a bill of indictment, and it's got to say it's a true bill. I have exclusive content available on my website and on Patreon, and I want to thank my subscribers here and now for all the support you're providing. A whole bunch of people chipping in a little bit adds up pretty fast, and it's all appreciated. And so my website has 2 subscription levels, and I accept cryptocurrencies. My Patreon has 3 subscription levels. My website, there's the basic subscription level is $29.99 a year for the videos only, and it's $49.99 a year for the videos plus unlimited consultations. Now, my unlimited consultations do have their limits. Because I'm not a liar. Well, I meant an attorney. No, I meant a liar. But I can tell you what I would do under certain circumstances and where to find the forms. So, the only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit, but I cannot fight all the battles. I need other people being on point and fighting the battles too. And so, Now the unlimited consultations does not mean that you email me every 5 minutes, and because I expect you to do a certain amount of homework, and if you have intelligent questions, I'm more than happy to entertain them. But whether you are supposed to notarize something or get witnesses, that's a personal preference. I'm not babysitting people. It does not include babysitting, okay? And so you're expected to do a certain amount of homework, and it does not include babysitting. Some of my exclusive content on my website and on my Patreon channel are Arlington Private Information Share. That's 9 videos by itself. Land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training, federal habeas corpus training, revocation of voter registration training, criminal complaint training. There's actually about 3 videos on that, and there'll probably be more. And lawsuit training, that one hasn't been uploaded yet, but there'll be more than one on that, because that can be kind of complicated. Other training requests, Northeast Private Information Share videos, okay? And so I've uploaded a bunch of videos from the Northeast Private Information Share. So, and other training requests based on if it's something that I can do, I'm open to requests. All forms, files, and other instructions are available for free on my 2 private groups at Yahoo Groups and Google Groups. And the exclusive content is available on my website and on Patreon, and you can buy a subscription there. And there's my Patreon. It's patreon.com, Sovereignty International. So, some of the privileges. The registration equals a privilege, okay? So a birth registration, that's a privilege. A vehicle registration, that's a privilege. Any registration is a privilege. Social Security is a privilege. Commerce is a privilege. It's always about competence and incompetence. There's no such thing as an incompetent sovereign. That's why there's always a bar member waiting to represent you. Only imbeciles use liars, or I meant attorneys. No, I meant liars. See the bar members' videos. When we're given birth, our parents get a birth certificate for us, and then the Social Security number. In high school, we get a driver's license. After high school, we become employed for the government with the Social Security number. And so we got to understand what all this stuff is, and we got to walk away from it. The so-called courts treat everything as separate issues. We have to quit these privileges. We need to treat it like we have multiple fish hooks in us, and we take them out one at a time. Becoming sovereign is not an event. It's a journey. We grow into it. In the scriptures, it says line upon line, precept upon precept, here a little, there a little. And so it's important also to network with other like-minded people. That's also very important, because none of us knows everything. And there's a lot of disinformation out there too. The Jesuits are busy trying to spread all their disinformation. So some of my other videos are Bankster Thieves playlist, Roman cult playlist, bankrupt corporate so-called government, bar members 1 through 4, do-it-yourself how not to volunteer for the selective service in the draft, martial laws here, do-it-yourself no income tax, do-it-yourself free mail, do-it-yourself kangaroo courts 1 through 15, Canada Border Pigs playlist, bar members and their Satanic Connections playlist. War is when your government tells you who the enemy is. Revolution is when you figure it out for yourself. So I have some plates available and laminated Texas sheet codes. And so this is one of the plates that I have available. And this would be a front one if you wanted one of these. There's actually, I sell one plate and one laminated Texas sheet code for $50. This would be the back plate if you want one. But there's also other ones like this one. This is the one that, or similar one to this, is one that I have on my car right now. And so, but it's not perfect. I mean, Republic of Texas, I like this one back here, Texas Republic, way better. And private property, that's on this one too. But no trespassing and exempt and non-commercial, not for hire. There's all things that I think should be on there. But I don't get harassed with this one either, I'll tell you. Here's another one. It's got a gray background with blue text and yellow text. And so this is another one that's available. If you order them, let me know which one you want, whether you want the gray background or the yellow background, or this other one right here. And so here's another one. You notice that the map of Texas, so there's a couple different styles. There's one with the current Texas flag, and this older one is the Bonnie Blue flag. It's patterned after. Other than that, the text is pretty well the same. I like the Texas plates because they can be used anywhere, because all states, Canada and Mexico included, are required to recognize Texas law. That's why people in Texas, you know, I can't believe someone actually sent me an email saying, where does it say that they're required to recognize Texas law? Well, hello! Why do you think people with Texas plates can drive in Canada? Do you think they stop them and say, your plates are illegal here? Hello? Is anybody home? So anyways, this is Texas Transportation Code 502.003, registration by political subdivision prohibited. A political subdivision of this state may not require an owner of a motor vehicle to register the vehicle, pay a motor vehicle registration fee, or pay an occupation tax or license fee in connection with the motor vehicle. So that means a driver's license, okay? And you don't have to pay the registration fee or the tax, or you don't have to register the vehicle. No one can require it in Texas. And so if you make up your own plates, of course you're going to have to depend it in other locations. And I would make sure I had a Texas address, even if I was traveling in another state, to show that I'm from Texas. Of course I do, but not everybody has one. So if you're going to use them in another state, I would suggest you get a Texas address. I like the Texas plates again because all states, Canada and Mexico included, are required to recognize Texas law. And this is the Texas Transportation Code 501.004, the Certificate of Title Act. This chapter applies to a motor vehicle owned by the state or a political subdivision of the state. In other words, it's for government-owned vehicles. And so that's the only way you can get it registered, is there's got to be a certificate of title first. So anyways, it's government-owned vehicles. So again, now these two sites right here are actually on Catman's Forbidden Zone laminated sheet. I don't make those available. Catman made me take a video down because I was making them available. So I don't make them available. If you want to get those, get that. I would suggest you contact Catman or just make up your own. Whoops, back here. You can get one plate and one probable cause lamination for 3 pieces of silver, 1 troy ounce each, or $50 in military script / Federal Reserve notes / fake money. Before you do this, you need to be prepared to defend it. That's why I have the card in my car, because the discussion should end right there when I show them that nobody's required to register their vehicle. And my PayPal is engineerwin@hotmail.com, and you can get the Forbidden Zone laminated sheets from Catman at catman1@gmail.com. And that his sheet has this on it, these codes, and which are useful. Either that or you can make your own up. Anyways, my probable cause sheet is good because and you need to check your state statutes again. In Texas, a traffic offense is not a crime, and so but you need to be able to defend that. Before any police officer stops you, they must have probable cause. Article 4 Amendment prohibits law enforcement officers from arresting citizens without probable cause. Arrest made without probable cause violates the 4th Amendment. Holding involuntary civil confinement is a massive curtailment of liberty, is tantamount to infringement of being arrested, and can be made only upon probable cause. This is a probable cause, arrest and probable cause laminated sheet right here, and all of the sites I'm going to be going through here in this presentation. The test for the police officer's sufficient basis for probable cause is, did the officer have a sufficient basis to make a practical common sense decision that a fair probability of crime existed? Once the officer's actions fail to satisfy this test, it may appear that no reasonably objective officer could have believed that probable cause existed to make an arrest. And the Ninth Circuit Court of Appeals, citing cases from the U.S. Supreme Court, 5th, 7th, 8th, and 9th Circuits, held that, quote, by definition, probable cause to arrest can only exist in relation to criminal conduct. Civil disputes cannot give rise to probable cause. And so a traffic offense is not a crime in Texas. Okay, and so then this is the other side of the probable cause, talks about false arrest, and penal code stuff in Texas. Okay, you're going to have to find similar stuff in your state if you're not in Texas. This is, perhaps it should be mentioned that as a general rule, a person is placed under arrest when he's deprived of his liberty by an officer who intends to arrest him. It is not always necessary for the officer to make a formal declaration of arrest. A motorist stopped by a traffic officer for a traffic offense would be considered arrested, even if the motorist was not specifically informed that he had been arrested. Any restraint, however slight, upon another's liberty to come and go as one pleases, constitutes an arrest. And this is Texas Penal Code 3810, bail jumping and failure to appear. An offense under this section is a Class C misdemeanor if the offense for which the actor's appearance is required is punishable by fine only. Okay, so again, bail jumping and failure to appear is punishable by fine only. Conviction of a Class C misdemeanor does not impose any legal disability or disadvantage. That's Texas Penal Code 12.03. And Texas Penal Code 12.23 says that an individual adjudged guilty of a Class C misdemeanor shall be punished by a fine only, not to exceed $500. So that means, well, here it is. This is Texas Government Code 79.001. A crime means a misdemeanor punishable by confinement or jail, or B, a felony. That means a Class C misdemeanor is not a crime. And a defendant means a person accused of a crime. So if they're calling you a defendant, they're saying you committed a crime. That means they prejudged the case. If a Class C misdemeanor fails to be a crime, then it's by definition of a civil matter, which means it's an extortion racket. And furthermore, they may not issue a warrant. This is Texas Transportation Code 707.019, failure to pay civil penalty. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued. And the imposition of a civil penalty may not be recorded in the owner's driving record. So if they issue it, they don't have any authority. They're nothing but thieves. That's why I do my judicial complaints. A Class C misdemeanor is not a crime. In Texas, a police may not arrest you for a Class C misdemeanor. If they do, it's false arrest. The only thing the plaintiff needs to do is to allege a false arrest, is either 1, that the defendant made an arrest or imprisonment, or 2, that the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. Okay, so again, they're saying the plaintiff, so you got to file a lawsuit. Is the way that works. And then when the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. The burden is upon the defendant to show that the arrest was by authority of law. So again, a Class C misdemeanor is not a crime, so then it's false arrest. If the owner of a motor vehicle fails to timely pay the amount of the civil penalty imposed against the owner, an arrest warrant may not be issued for the owner. And a capias is not a warrant of arrest. Okay, what they do issue is a capias. And a capias means a writ that is issued by a court having jurisdiction. Okay, so they gotta have had jurisdiction. You gotta give it to them. In other words, they don't just presume they have jurisdiction. You gotta give it to them. Of a case after judgment and sentence, they gotta have held a trial. Capias pro fine means a writ that is issued by a court having jurisdiction of a case after judgment and sentence for unpaid fines and costs. And a capias is not a warrant of arrest. Okay, so that's what they do in Texas, is they issue a capias. If a cop stopped me for speeding in Texas, I would say I don't have a problem providing whatever you need, but I got a couple questions first. What's your probable cause for stopping me? And if he stopped me for speeding, he'll say that. And I'll say, well, speeding's a Class C misdemeanor, and a Class C misdemeanor is not a crime in Texas. And probable cause requires a crime. So I ask you again, what's your probable cause for stopping me, or should I just be on my way? And you don't give them anything. Okay, you don't give them anything. Your name, nothing. And it's abuse of official capacity. When they turn on their emergency lights, and it's not a crime, that's abuse of official capacity, because a public servant commits an offense if, with intent to obtain a benefit or with intent to harm or defraud another, he intentionally or knowingly misuses government property, services, personnel, or any other thing of value belonging to the government that has come into the public servant's custody or possession by virtue of the public servant's office or employment. They turn on their emergency lights and there's no emergency, then that's abuse of public official capacity. And they always use this failure to identify, okay? And so a person commits an offense if he intentionally refuses to give his name, residence, address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. Well, first of all, if that cop is stopping you for speeding, he's not in his official capacity as a peace officer, because there's no crime. He's in his capacity as a revenue officer, and it's not a lawful arrest. So you don't have to give him anything. It's got to be a lawful arrest. And it's official oppression. Okay, when he starts threatening you with this Texas Penal Code failure to identify, that's official oppression. A public servant acting under color of his office or employment commits an offense if he intentionally subjects another to mistreatment, to arrest, detention, search, seizure, dispossession, assessment, or lien that he knows is unlawful, intentionally denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity, knowing his conduct is unlawful. For purposes of this section, a public servant acts under color of his office or employment if he acts or purports to act in an official capacity or takes advantage of such actual or purported capacity. So if he's got his military uniform, he's claiming to be in his official capacity. But notice he says that it purports to act in an official capacity, because when they go outside their authority, they cease to represent the government. So it purports to act in an official capacity. That's correct. And that's Texas Penal Code 3903, official oppression. So they're engaged in official oppression. And then a person commits an offense if he impersonates a public servant with intent to induce another to submit to his pretended official authority, to rely on his pretended official acts, or knowingly purports to exercise any function of a public servant or a public office, including that of a judge in court, and the position or office through which he purports to exercise a function of a public servant or a public office has no lawful existence under the Constitution or laws of the state or of the United States. And that's a felony, a third-degree felony. And that's Texas Penal Code 3711, impersonating a public servant. And So the judge, when he's railroading you, he's not a judge, okay? Judges only hold office during good behavior. And that's going to be part of my next laminated sheet that I'm going to present about kangaroo court survival. Anyways, judges only hold office during good behavior, and if they're not in good behavior, then they're not a judge anymore, okay? And then that court is not a court. It may be in the courthouse, okay? It can be in the courthouse, but just because it's in the courthouse doesn't mean it's a court. Just, it's not a court. This is 18 U.S.C. 241, conspiracy to violate rights under color of law. If two or more persons conspire to injure, oppress, threaten, intimidate any person in the state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of his having so exercised the same, they shall be fined under this title or imprisoned not more than 10 years or both. Okay, so again, conspiracy to violate your rights. If that judge is covering up that pig's crimes, that's a conspiracy. 18 U.S.C. 242, violating rights under color of law. This is similar to official oppression in Texas. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the constitutional laws of the United States shall be fined under this title or imprisoned. And then 18 U.S.C. 247, damage to religious property, obstruction of persons in the free exercise of religious beliefs. If they're subjecting you to their satanic religious ceremony, whoever, under any circumstances referred to in subsection B of this section, intentionally obstructs by force or threat of force, including by threat of force against religious real property, any person in the enjoyment of that person's free exercise of religious beliefs or attempts to do so shall be punished as provided in subsection D. Okay, so again, if they're subjecting you to their satanic religious ceremony, which is what it is. 18 U.S.C. 2707, and this is their good faith defense. Okay, so, but you can pierce it because you can defeat their good faith. For example, a capias, they call it in their computer system, it's a warrant, okay? And so what they're doing is they're setting up their good faith defense, okay? But the argument is that they're required to know that the warrant can't be issued. And so I don't care what their computer system says. It's not a warrant, it's a capias. They're required to know that a capias is not a warrant. Anyways, that's their requirement. But the defense is a good faith reliance on a court warrant or order, a grand jury subpoena, legislative authorization, or a statutory authorization, including a request of a governmental entity under Section 2703F of this title, a request of an investigative or law enforcement officer under Section 2518 of this title, or a good faith determination that Section 2511.3 of this title permitted the conduct complained of, is a complete defense to any civil or criminal action brought under this chapter or any other chapter. Okay, so again, they claim good faith. They claim that to get away from it. I mean, that's what their bosses hire low intelligence thugs so they can claim good faith and get away with it. And this is Texas Code of Criminal Procedure, Article 38.23. No evidence obtained by an officer or other person in violation of any provisions of the constitutional laws of the state of Texas or the constitutional laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. It is an exception to the provisions of subsection E of this article that the evidence was obtained by a law enforcement officer acting in objective good faith reliance upon a warrant issued by a neutral magistrate based on probable cause. Well, if it's a capias, it's not a warrant, okay? And that's why they're setting up that good faith defense by calling it a warrant. But they're required to know that they cannot issue a warrant. Government officials are required to know the law. Government officials are required to know that a warrant may not be issued. A capias may only be issued after they get jurisdiction and hold a trial and a conviction. Any denials of due process or bad behavior by the judge, they always deny due process in countless ways. That's why I recommend that you have one of my kangaroo court survival laminated sheets with you in their so-called court. And that's what's next. And this is Article 3 of the Constitution of the United States. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and Inferior Court shall hold their offices during good behavior and shall at stated times receive for their services a compensation. Okay, so the point being is that they only hold office during good behavior, and if they deny good due process, that's bad behavior. This is the laminated card. This is one side of it. There's a lot of stuff on here, that's for sure, but I wanted to get as much on there as I could. Fraud upon the court is fraud which is directed to the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function. In other words, it's where the impartial functions of the courts have been directly corrupted. So he's bought and paid for a clerk masquerading as a judge. That's bad behavior. That's fraud upon the court. This is the backside of the same thing. So if you go here, it talks about good behavior versus bad behavior, and then talks about jurisdiction and challenging jurisdiction, and then talks about subject matter jurisdiction. And then it talks about in Texas how the county attorney represents the state of Texas, and a malicious prosecution, and a void judgment, and impersonation. Okay, so these are crimes that they commit. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Once challenged, jurisdiction cannot be assumed, it must be proved to exist. There is no discretion to ignore lack of jurisdiction. Okay, so if they ignore it, then there's no discretion to ignore it. Okay, again, it's bad behavior. If they don't resolve that issue, then it's bad behavior. It's not a court. Where jurisdiction's contested, the burden of establishing it rests upon the plaintiff. That's why you file a judicial complaint. The burden of proving jurisdiction rests upon the party asserting it. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. However late this objection to jurisdiction has been made, or may be made in any cause or an inferior or appellate court of the United States, it must be considered and decided before any court can move one step further in the cause, as any movement is necessarily the exercise of jurisdiction. The court has no jurisdiction to determine its own jurisdiction, for a basic issue in any case before a tribunal is its power to act, and a court must have the authority to decide that question the first instance. And a departure by a court from those recognized and established requirements of law, however close apparent adherence to mere form and methods of procedure, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. So if they deny you your constitutional rights, they don't have jurisdiction. The burden shifts to the court to prove jurisdiction. The fact that the petitioner was released on a promise to appear before a magistrate for an arraignment, the fact is circumstance to be considered and determine whether in the first instance there was probable cause for their arrest. And that's true. If they don't have probable cause, then the rest of it's moot. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. When liberty and freedom are at stake, your silence isn't golden, it's yellow. Where a court failed to observe safeguards, it amounts to a denial of due process, and the court is deprived of jurisdiction, of juris, okay? Subject matter jurisdiction. Not every action by any judge is an exercise of his judicial function. It is not a judicial function for a judge to commit an intentional tort, even though the tort occurs in the courthouse. When a judge acts as a trespasser of the law, when the judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are void of no legal force and effect. Okay, so this is all on my Kangaroo Court Survival laminated sheet. Now these are available for $10 a piece, and if you get a plate, then make me an offer. But if you want to order them separately, that's the one side of the kangaroo court survival, and there's the other side. And so, again, they're available. If you get them with the plate, then make me an offer. If you get them separately, then I'd like to get a $10 donation. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Okay, that's Federal Rules of Civil Procedure. Defense of lack of jurisdiction over the subject matter may be raised any time, even on appeal. Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. It's a void judgment. A county attorney shall represent the case of the state in all cases in the district and inferior courts in their respective counties. Okay, so anytime the state of Texas is involved, that prosecutor better damn well be a county attorney. And if he's not, and the judge knows it, I guarantee you, then it's a conspiracy. Okay, and because there's no crime with a traffic case, it's malicious prosecution. Okay, because there's no probable cause. They don't have probable cause to stop you, and so it's a false arrest. There's no crime. Although probable cause may not be inferred from malice, malice may be inferred from lack of probable cause. A universal principle as old as the law is that the proceedings of a court without jurisdiction are a nullity, and the judgment therein without effect either on person or property. When a judge acts where he or she does not have jurisdiction to act, the judge is engaged in an act or acts of treason. A court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. Where there is no jurisdiction, there is no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Say. Okay, and that's a federal court case citing a U.S. Supreme Court case, Bradley versus Fisher, and that is citing Lord Coke in Coke's commentaries on the laws of England in the 1500s. Brutum fulmen, an empty noise, an empty threat, a judgment void upon its face, which is in legal effect no judgment of all, and by which no rights are divested, and from which none can be obtained, and neither binds nor bars anyone. And that's Black's Law Dictionary, 4th edition. I went and filed a lawsuit in Texas court one time, and against FedEx. FedEx removed it into federal court, and I dumped on the judge. I kind of felt guilty afterwards because he was real nice. I never had a judge be so nice to me. But yeah, I dumped on the judge, and I told him that I have nothing but contempt for your so-called courts, an inferior court of limited jurisdiction. And I told him that everything he does is brutum fulmen. And he ultimately dismissed the thing. I told him I wanted it remanded back to Texas, and he didn't. And ultimately dismissed it because I refused, or I couldn't participate in fraud by doing their electronic filing scam and giving them evidence that I'm one of their slaves. And so he ultimately dismissed it, and in his dismissal, he said that I said that everything he does is brutum fulmen. Anyways, an officer who acts in violation of the Constitution ceases to represent the government. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. That's when these judges are impersonating a public servant, then he doesn't have a shred of immunity. In arriving at our decision in this matter, we do not depart in any way from our holding in Hundling versus Jensen that the doctrine of judicial immunity extends to courts of limited jurisdiction. But when a minor magistrate acts wholly without jurisdiction, civil liability attaches for his malicious and corrupt abuse of process and his willful and malicious oppression of any person under the pretense of acting in his official capacity. Woohoo! Kick his butt. A person, okay, and so what it is it's impersonating a public official, for starters. Texas Penal Code 3711. A person commits an offense if he impersonates a public servant with intent to induce another to submit to his pretended official authority or to rely on his pretended official acts, or knowingly purports to exercise any function of a public servant or public office, including that of a judge in court, okay? Well, think about it. If, remember, if an officer who acts in violation of the Constitution ceases to represent the government. Okay? And so if he's in bad behavior, then he's not representing the government anymore. And so therefore he's not a judge or a court. Okay? And so knowingly purports to exercise, okay, that's why they're purports, okay, because he's not. To exercise any function of judge or public servant, including that of a judge in court, and the position or office through which he purports to exercise a function of public servant or public office have no lawful existence under the constitutional laws of the state or the United States. Well, think about it. If that prosecutor is impersonating a public servant, and because he's not a county attorney, and it's only a county attorney that's supposed to be representing the state of Texas, and the judge knows it, then it's not a court, and it's no lawful existence for this, whatever this is, under the laws or Constitution of the United States or the state. An offense under this section is a felony. Change will not come if we wait for some other person or some other time. We are the ones we've been waiting for. We are the change that we seek. So the bottom line is that its subject matter jurisdiction is everything, okay? Due process is everything. They deny due process all the time. When you get mixed up with these privileges, then you turn yourself into a slave. But the bottom line is you're still entitled to due process, and they deny due process all the time, and they lose subject matter jurisdiction. Do not give them jurisdiction. If they're going to go, think about it, if they're going to go and violate your rights, all of a sudden you think they're going to start honoring their oath of office when they started off right off the bat denying you due process. So why would you trust the whore to give you due process if they denied it right off the bat? Always make a special appearance. Point out their denials of due process. Do not allow them to enter a plea. It gives them jurisdiction. You're not entering a plea. I don't give you jurisdiction. I actually did that, and the judge actually said, well, you got to show up at this hearing so that you can make a plea. And I told him, you're not entering a plea for me. I don't give you permission. You have already demonstrated that you prejudged this matter as a bought and paid for clerk for the prosecutor. So are we impersonating a judge today, are we? Demand that it be dismissed immediately. Anyways, it's all about due process, and you have to challenge jurisdiction. Do not give them jurisdiction. They say, I'm going to enter a plea. You tell them, no, you're not, and stick to your guns. And you know, they're nothing but thieves and pirates. So it's all about due process. Due process is everything. They deny due process in 100 different ways every day. It's normal business for them to do that, and the more ways that you point out their denials of due process, the more difficult it is for them to proceed. And you tell them, I want this case dismissed. Why would I expect you to give me due process when you denied it right at the beginning? It ain't happening. Dismiss this case now. And so, absolutely, that's where I'd be going with it. Thanks for watching. Have a great day.